Welcome everyone to our program on the coronavirus. Like you, the lawyers at Berding Weil have been fielding many questions, challenging ones, on how to deal with the virus and its impact on community association operations. This is Steve Weil, and again, we're glad you could join us today. So we formed a team to deal with these issues. Up in Walnut Creek, myself and my partner Andrea O'Toole and Maria Cow, and our partner Nick Rogers, who's joining us on the program today, and down in Southern California, Tim Flanagan, Maria Cow, and Pamela Richardson. So we'll have this information up a little bit later, so you'll be able to email us if you'd like with any questions. So today we're going to talk about the need for the board to adopt emergency rules to deal with the virus issues. And we say that as opposed to the board simply making pronouncements to help provide to members clarity, to help manage their expectations about what they can expect in terms of access and safety, those issues, so that the board has a record establishing that they have been reliable and properly doing their jobs, and also for legal protection, as Nick is going to describe. Now, I know many of you work with the communities that our firm is representing in construction defect cases, and those are being impacted to some degree by court orders, which have stopped the court system dead in its tracks for now. Our litigators have met this week. We have different strategies for taking advantage of this lull so that there will be as minimal a delay or disruption of your cases as possible. And you can be expecting updated disclosure and status letters soon. And finally, one thing that's become apparent is, as we talk to clients about adopting the rules, that some have not yet adopted election rules or have not figured out how to implement the balcony inspection bill, and those requirements keep going. So just want to draw that to your attention, and again, our team can help with that as well. So here are the topics we're going to cover in today's program. Again, these are all going to be pretty familiar to you, I'm sure. Where we're going to start is with the government shelter-in-place orders. And Nick, let me turn the program over to you, and you can bring everybody up to speed on that.
Hi, my name is Nick Rogers, and as Steve said, I'm a partner at Berding Weil. My practice focuses on defending directors, officers, community associations, and property managers in litigation. I also provide corporate counsel services on a range of subjects, including conflict resolution and risk management practices. So my perspective is really focused on looking at how to minimize risk, both the person and property, and also in general litigation risk, 2 months, 5 months, 6 months, a year down the line. So when we talk about the government shelter-in-place orders, our industry has come a long way in just over a week under these orders. As we know, the purpose of the orders is to ensure the maximum number of people in the state self-isolate. Now, there's exceptions for certain essential businesses and activities, and management is an essential business and should maintain the continuity of essential operations for the associations we serve. Now, boards are not, but they still need to meet in open and executive sessions, both as needed. And we will discuss during our program today the best way to use technology to make that happen. So what does all of this mean? Well, our presentation is aimed at assisting you managers navigate these essential operations, like posting notices, conducting meetings, conducting elections, restricting access to common areas, and ensuring critical deadlines are not missed, and knowing when to seek legal counsel and use, as Steve had said, our rulemaking powers to both communicate and regulate the association. So emergency rules. Civil Code Section 4360D is what we're going to focus on here. Now look, risk. This program is identifying risk in a number of the different slides we're going to cover today. And we're all aware to varying degrees that we're living in a time of heightened risk. An association in general, that Francis T case on the slide there that says premises liability, An association has a duty of reasonable care to protect users from foreseeable risk of harm. We know the virus is highly contagious, so our associations need to take affirmative steps that document their efforts to minimize that risk. It's not a pleasant thought, but again, the threat of lawsuit against our associations arising from an alleged failure to take appropriate action is going to begin to arise as time goes on. So now is the time for our associations to be proactive and minimize the risk of personal injury and future litigation. Civil Code 4360D is our emergency rulemaking statute in the Davis-Sterling Act. It permits associations and the boards more primarily to adopt rules without the 28-member notice requirement if rules are necessary due to imminent threat to public life or safety. And that's where our associations are right now. So whether it's shutting down common areas, staying architectural projects, determining who gets access to association common areas or the development itself and for what purpose, conducting business, permitting certain members to conduct types of businesses from home, or how we approach enforcement matters. These are all areas that may require emergency rulemaking to both communicate, as Steve was saying at the opening of the program, communicate to the membership, managing expectations, while also implementing appropriate and reasonable risk management strategies. But one size does not fit all for these rules. Each condo association or stock co-op or planned event development can have wrinkles stemming from the physical layout of the development or its particular governing documents. So it's really important, particularly since our boards are moving fast, management is moving fast, we're responding every 48 hours to different comments and changes in community standards, that this is done with competent legal counsel.
Yeah, I think that's right. You know, this idea about the customization of the rules. So the rules are going to be different in a condominium than in a detached single-family development. Going to be different if there's a guard at the gate, or if there's a concierge desk that's staffed or not staffed, if there are multiple entrances to a building, multiple elevators. Probably there will be differences based on where a community is located, a particular part of town, the nature of traffic, and the kind of public access, you know, that's otherwise provided. So each one of these rules has got to be tailored to that. So one thing we do want to emphasize is, to some degree, it's got to be business as usual. The board has got to continue holding board meetings. Decisions are going to have to be made. Bills are going to have to be paid. Homeowner complaints about things unrelated to the virus are going to need to be addressed, dealt with, possibly investigated. So procedurally, the biggest difference is going to be that the meetings you're conducting, your clients are conducting, are going to be virtual. And there are a lot of tools online to do that. FaceTime for Apple products, Skype, GoToMeeting, Zoom are just a few. There are a couple more. And you're going to be noticing these meetings and posting agendas, both electronically, that is on websites, by email, and also posting on common area. The key thing here for directors is to be able to manage the member forum, member comment period. And that will require some ability to control the mute function, and managers on the line maybe want to practice internally to make sure that that happens. Obviously, we're going to keep minutes the same way we do, and the minutes should reflect, as should the agenda, that the board has every month or every meeting for the foreseeable future dealt with issues to the virus, how it's managing with vendors, steps that it's taken, challenges that it has, whatever it is, just to show that the board is on top of it. One tip I might offer, based on the several meetings I've attended virtually in the last week or so, is if you're planning on starting your meeting at 6:30, actually start it at 6:15, because it's going to take a few minutes for people to log on. There's going to be a little bit of giddiness, at least in my experience. somebody's going to come in late, announce themselves. It's a little disruptive. So it's going to be a lot easier to actually start the business part of the meeting if you start your meeting a little bit sooner. One of the things that we discovered was that if you have a lot of users on a line, the ability to control the virtual environment can be compromised. And so if you're going to have, for example, an annual meeting or a membership meeting in a large community where you may get 100 or 200 people calling in, you'll want to check with the vendor you're using to make sure the system is compatible and if there are any special considerations. So what I've spoken about so far are the open board meetings. Nick, let's talk about executive session and member meetings.
Thanks, Steve. So when and why a board is holding an executive session is always going to be the tougher question, as the normal 2-day notice provisions are still going to apply. And that session, again, will be held by telephone or conference call line or similar technologies discussed by Steve. And that is, IDRs, disciplinary matters, assessment matters, and legal matters. Those are your executive session type topics. One tip I would give, a practical tip that I've experienced this week, is a lot of times our executive sessions follow our open session meetings. And a meeting I just had last night, the open session meeting, the number was given out for the conference call to the entire membership, and it was noticed that way. But a second meeting number was not given for the executive session. So as we went into executive session with the board and legal counsel, we ended up having to hang up and get a second dial-in number because we had a number of members that were still on the line. So something you might want to think about as managers when you're planning these executive sessions is to actually, you have the open session number that's broadcast to the membership, and then you're going to want to have an executive session number that just goes to the board, legal counsel, management, and maybe the particular member that's involved in the hearing.
Yeah, I think that's a good point. And you might think, well, maybe we can flip it around and have the executive session first, and then continue with the open meeting. But what I've found is that there are going to be members who will log on, 15 minutes before the notice time, and that will be disruptive to the executive session and not an efficient way of handling that. So let's talk about the election of directors. These also can be handled by Skype or a similar virtual tool. And really, the video will be of the election inspector who will be counting the ballots. Parenthetically, probably should be using gloves for the entire counting procedure. And then everyone will be able to observe it. And also, that's a video that should be recorded. In terms of other elections, and we'll come back to election of directors in a minute, but other elections like amendment of the governing documents, proposed special assessment increases, bank loan votes, and that, those are going to be difficult now. Not so much, or not only because of the virtual challenges and ballot counting procedures and that, but also because it's going to be difficult to educate members and persuade them that the board's approach to a problem, planned special assessment, for example, is a good one. And without having people in a room to discuss the issues, maybe to consider presentations by experts, or like in the governing document amendment scenario, having the lawyers explain some of the new terms, it's going to be difficult or more challenging to get these things passed. So again, maybe we post videos, YouTube's on website, maybe we take advantage of Nextdoor, not something we might otherwise do. But definitely boards are going to be needing to think about what those procedures are. So we've gotten a lot of this question, can we just defer the meetings? Let's talk about board meetings. Many governing documents say boards shall meet monthly. Some say quarterly. There are boards that have chosen to defer to meet quarterly, and that's probably okay, so long as they're figuring out how to do a couple of things. One, they still got to do monthly reconciliations of their checking account, reserve account, general ledger, that sort of thing. And number two, the board needs to be able to delegate to a subcommittee of less than the entire board, or if they want to meet, without notice under the Open Meeting Act, or to the president or the manager, in order to be able to get things done between meetings. I do think it's important, though, if the board is going to defer their meetings to quarterly instead of monthly, to be able to have a good reason why, to be able to articulate that to the members. And later, when Nick gets into these lawsuits about, alleged improper board conduct, you want to be able to say, you've tried to the greatest degree you can to stick to, the normal rules and the bylaws. And I think it will be difficult to justify deferring meetings where the board could meet with the members virtually. So keep that in the back of your mind. The election of directors, especially this year, as we all know, is extremely challenging. There are a lot of deadlines that start 3 and 4 months actually prior to the date of the ballot count. Under the Corporations Code, the board generally has the right to extend an election date by 60 days. Meetings must be held generally within 15 months of the previous meeting. Again, if we're going to defer the elections, we're going to need to justify why. And also remember that the existing terms will last longer than a year, and the new terms will last shorter than a year. And I think that's okay, but just be aware the question may come up. So that's so much for governance. A lot of the questions we're getting now, and I'm sure you are too, have to do with building control, security, and access. Nick?
Yes, I would definitely say that over the last, certainly the last 4 or 5 days, the number of access issues is the type of many of the questions that we're receiving and speaking with about our boards. So the point of the shelter in and stay home orders is to ensure the maximum number of people self-isolate. But as we know, there's great debate in our society right now over what that exactly means and how we effectuate those goals. But for our associations, if the goal is, social guests, if the goal is to have people self-isolate, social guests entering a common area lobby at a condo association, now that's a question that is probably going to be answered as probably not allowing that access. But a simple issue such as that becomes even more complex when you have guests arriving at the guard shack at a gated community like Steve was talking about earlier. And the point is, the boards need to meet. They need to flesh these issues out, both with, thinking about their particular membership, their particular CCNRs, the physical layout, as Steve was talking about, versus a condo association versus a plan development. We're going to have to meet as boards and then come to some decisions. I can tell you that views on this have changed greatly in just a week or 10 days. Earlier, I'd say a week and a half ago, we were getting, when the orders were first issued, the questions we were getting from our managers were primarily, how do we keep the gyms open, the pool open? What can we do to kind of keep business running as normal? But starting Friday and into this week, I would say the overwhelming majority of the responses I've received is, what can we do to close them up? And that's from a risk management and promoting the goals of the order perspective. And that's the perspective someone like me, a litigator, is going to be looking at. And regardless of what decisions our boards come to, the importance, again, is to document, as Steve was saying, using rules to communicate and have a clear trail of why are we making the decisions we're making. So to me, it's about discussions with our board, making these decisions, reducing these decisions to writing, and then sitting out there is where on the slide it says limiting or eliminating access. It's really the practicality of what can we do. Sometimes gyms have fob access or hard locks. We have safety codes to think about. Actually effectuating and enforcing the rules that we're coming to, whether it's at a guard gate and someone drives up and says, well, I'm here to to take care of my mother, I'm essential. We first need to get our policies, and then the next wave is going to be, how do we actually enforce these policies? So again, whether it's the pool, the exercise room, social guests, deliveries, etc., our associations, again, will be really well served to work with managers and legal counsel to balance these issues during our initial meetings, coming to some decisions, and then figuring out a way to use the rulemaking authority to mitigate risk exposure for that particular development. They're going to need to be customized.
So Nick was talking about limitations in terms of residents using facilities, social guests, which includes family members, which in our opinion should be excluded, certainly could be excluded, and in some cases maybe should be included. And then we have a different kind of access, and that's from vendors, the Bud Light truck obviously being an important vendor there. But from the association's point of view, we want to be able to maintain, common area components, the things the association is responsible for. So plumbers, balcony contractors seem it's pretty evident that they would be deemed essential, almost always plumbers, certainly. And if we have new burdens added to our sewer systems and plumbing lines, as people have been anticipating, you're going to want your plumber on speed dial for sure. Dangerous balconies. In the middle of, there are going to be a lot of projects right now in the middle of balcony repairs and inspections, and I think those are going to be okay. In some communities, boards are taking the position that landscapers are essential, and this may be communities where there are dog parks, for example, or with regard to pools where there's a concern about algae getting in the pools if they're shut down. Again, I think each case is different, and to some degree, we may not have control over that. If the landscaper says, I don't want my staff out there, maybe we're going to push back and say, well, can you send at least 2 people instead of 10? Make sure they're wear masks, they're more than 6 feet apart. So we're probably going to have some dynamic like that. Although I think for the contractors, the pressure to keep their cash flow going, to keep their folks employed is also going to be very high as well. One thing we can do in some communities, again, depending on the nature, the physical layout of the buildings, limit areas of access. You may want to shut down a staircase or 2, only use 1 elevator, have it be regularly cleaned. I mean, like twice a day at least. I've heard of some communities where they're doing it even more than that. You're going to want to post signs if you can. Wash your hands. We know it is obvious, but again, we're thinking here more along the lines of risk management. Let's see what else. We want to maybe talk about having gloves and booties and masks around as a way of also being able to demonstrate that the association is managing risk properly. So deliveries. So this happens to be my dog, Sophie. She's doing her part, trying to illustrate the point that UPS and the Postal Service, Amazon, are deemed essential under the shelter-in-place orders. You're not going to prohibit the delivery of food or medicine, probably not laundry, because you'll have a revolution on your hand. But again, you can limit where these deliveries happen and how they happen. For example, we wrote rules for a community the other day, which has established basically a delivery area. The vendor comes, brings their food. They call upstairs. The resident comes down and then retrieves their food. That may not be practical in all communities, and even where it is physically practical, there may be situations where the residents are not able to, either because they're disabled or elderly, to come downstairs. But nevertheless, that is something to think about. Pets are given special protection under the state and the local orders. We can take them out. We can drive to the food store, pet food. Although I do know in Alameda County, people were at a huge dog park and the sheriff came and chased them away. Nick, let's talk about assessments, operational authorities. Actually, I will. So the question's going to come up because people, as we know, many people have lost their jobs. Probably some people are on reduced shifts. Their income is declining a little bit. And so there's going to be some pressure on the board to at least consider making some changes in the current assessment methodology of collection. So are we going to eliminate interest and the late charges? The boards legally have the right to do this. Is the board going to reduce assessments? And generally speaking, I would say yes, the board has the right to do it. There are some issues to consider, obviously, including anticipated reserve needs and just what the association's funding is. Cutting back on an assessment where there are only 10% reserves is a lot different than one where the reserves are in the 50, 60% or higher. There are some governing documents that say assessments are to be levied equally per month in 1/12 increments. And so that needs to be considered if assessment changes are going to be made. Likely, there'll be little objection if the board is reducing the assessments, but later in the year or next year, if we try to catch up, there may be some concern there. Payment plan issues, reduction of the budget, again, these are within the scope of the board's authority, and they may, depending on what the delinquency ratios look like, want to consider scaling back on some services, at least temporarily. So here's a tough one. Are we going to lien somebody who becomes delinquent as a direct result of the shelter-in-place orders, jobbing impacts, that sort of thing? So, of course, the board has the right to, and you can say the duty to enforce its assessment collection policies. And in fact, if the boards have taken out loans to make repairs, the banks generally require that associations be fairly aggressive in enforcing the assessment collection policy. So if there are loans, that's a thing we're probably going to have to work through with the lenders if the board is going to defer the collection of assessments or cut back on its liens. Now, a few days ago, the federal government issued a moratorium on the foreclosure of mortgages which were insured by agencies of the federal government like Fannie Mae and Freddie Mac. According to CAI's national organization, they are monitoring whether or not there will be something similar with regard to private foreclosures or association foreclosures. As of right now, which is March 26, 2020, there have not been any such rules. If the board doesn't record a lien and out of a sense of good-heartedness, and then an owner ultimately files bankruptcy, the association's ability to recover delinquent assessments will be severely compromised, if not eliminated. And many of you may remember there was a case decided last year which basically said that the lien secures only the amount due as of the date the lien is recorded. So there are collection companies which are recommending recordation of liens a couple times a year. And so this issue may come up again as well. Nick, let's talk about your area, which is enforcement architectural control as it relates to potential association liability.
Yeah, thank you, Steve. So this is kind of a theme you're hearing from me on my slides, but when it comes to operational priorities and enforcement and architectural controls, enforcement, as we know, involves a duty to investigate a particular issue, enforcement matter in good faith and a manner consistent with our CC&Rs. So if the board meets this standard, they are protected from liability by what we call the rule of judicial deference and the business judgment rule. That's a lot of fancy legal talk for saying if the board investigates something and does so and reaches a decision that's consistent with the CC&Rs, if it gets sued, it has this very strong defense because courts have repeatedly and increasingly in the state of California stated expressly that they want to defer to the decisions of our boards that are made in good faith. Now, again, that doesn't mean our association or our directors can't be sued. It just means that once we get there, we have this very strong defense. Now, getting back to the rulemaking authority, why we're advocating writing rules and documenting these is because there's a fine line between making a decision, investigating the issue, making a decision, and documenting. For instance, pushing the regular meeting out, not filing a lawsuit, taking the steps that we take, and then versus not doing anything at all. If we don't do anything at all, then those really strong defenses aren't going to be there at the time of a lawsuit. So during this time when the courts are closed and meetings are difficult and resources stretched thin, it may be time for, not just adopting rules, but sending more warning letters, documenting the violations, but perhaps not throwing the book at the member, but we need to be very careful that we don't just simply ignore the situation. And again, this is a case-by-case issue. We still can't ignore health and safety violations like dog bites or reckless driving in the community, things that are an imminent threat to personal property or personal safety, bodily injury. But we have to be realistic about prioritizing performance of critical operations, again, with that emphasis on public health and safety. So this leads me to some final points. Violations of the shelter in place and stay away orders. In my opinion, those should be directed at law enforcement. I can't tell you what a particular health or police department is going to do right now when confronted with maybe someone who's having visitors, someone who's not staying 6 feet away, someone who is getting deliveries that are not essential but demanding them or demanding access into the communities. But I don't think these orders deputize our associations as the community enforcer unless they're presented with some really egregious behavior or violations. So if someone breaks into a common area gym that you've called that has been closed, I think that's a law enforcement matter, perhaps with a warning letter that's followed up. Obviously, we then want to get the room wiped down, but we need to make sure that we understand we're not the police. And that's created some thorny issues for me in particular, discussing with some of my gated communities. But the point is you work with legal counsel or management to try and work through those issues. Again, the second one is member written demands. We want you to close this, open that, don't do this, you should have done that. We also need to pay great attention to these written demands in letters or emails that are sent to our managers. I can't stress this enough. Those written demands for monetary or non-monetary relief, those should be sent to legal counsel for review to make sure that if someone is looking at to determine whether or not that's triggering a duty under relevant insurance policies as a potential claim. We as managers and lawyers, and certainly the board members, want to do all we can to preserve the association's rights under any insuring agreements in case a lawsuit occurs 6 months from now, a year from now, arising from or relating to that written demand. So as this occurs over the coming months and you managers are receiving these emails, which they're going to come, whatever the decision that's made by the board, close the common area, open the common area, you can bet you're going to get responses. You need to make sure you have your antenna up as asking yourself, is this a written demand for monetary or non-monetary relief? If you think it could be, you send it over to the lawyer to look at to make sure we get that tendered and preserve our insurance. My final point is with architectural applications. This should be noted, and I don't think we've said it thus far in the program. With respect to our rulemaking authority, our rules that we pass cannot be in direct conflict with relevant provisions of the CC&Rs. So it's a lot of times in the architectural process, Our CC&Rs have hard stops if the association fails to process a particular application in 30 or 60 days, meaning that application is deemed approved. So the association can't use its rulemaking authority in most instances to negate those hard stops. But emergency rules could be used to stay post-approval construction, meaning we don't want non-essential work in the project to take place. If there's a pipe break on the 4th floor, we're calling in the plumber to fix that. That's essential. But just because we approved, I don't know, some alteration to that same common area in the bathroom so you can put in a bidet or a new shower, that doesn't mean that that work needs to commence as soon as the approval is processed. So that's another example of emergency rules that can address an issue like this at this time. Steve?
Good one, Nick. Thanks. Yeah. So a client wrestling with adoption of rules in a senior community sent me an interesting quote. And it said this: as COVID-19 began spreading, a friend sent me a quote by Michael Levitt, a biophysicist and professor at Stanford University. He said, quote, "Everything we do before a pandemic will seem alarmist. Everything we do after will seem inadequate." And I think that's definitely true and worth considering. So here are some things. Business has to go on. Most things can be done without too much disruption. Maintenance duties, certainly to protect buildings and safety, need to go on. Bills need to be paid, and deadlines need to be attended to. It's really important for the board to have a good communication strategy. And by that, I mean, how are we going to let people know that the board knows what it's doing, that it's taking control over the community? We want to convey this sense of confidence and trust and respect to the directors, from the directors to the community. So regular communications, properly worded, provide that opportunity both for the board and the management to demonstrate to the members that their interests are being protected. As Nick says, some people are going to want boards to do more. Some people are going to want boards to do less. So finding that important medium, working with management, working with council, and then communicating it, I think is going to be essential to minimizing disputes to the extent possible. So before we just talk for a minute about questions, again, I want to point out our coronavirus team and encourage you to reach out to any of the folks up here on the screen. You can also reach us at our main numbers, and I'm sure many of you have those numbers as well. And these numbers are our back lines and maybe cell phone numbers as well. So I'm sure you've got many questions. I don't know that we can answer all of them, but please email us here, and we will take the ones of the broadest application and we'll respond in writing to you. But in the meanwhile, we just wanted to close with this. We've talked at a very high level, about some of the challenges, the very common challenges. But every community is going to have, nitpicky ones, or really, so ones that are very unusual for them. So I have a client, for example, that is considering buying a laser temperature, a laser thermometer, and they're thinking of taking the temperature of anybody coming into the building. And so is that a good idea, yes or no? How would it actually be implemented? What if somebody opposes? Somebody called me yesterday with this concern. A staff worker got sick and was sent home. Somehow she was able to get a virus test. It hasn't come back yet. The manager wanted to know, hey, what about the other employees? Should I tell them? And again, we kicked around some issues about proximity and the nature of the service, and how we're not doctors, and maybe that person just had a regular cold, don't know. Another person raised a question: if we learn that there is somebody with a virus in the community, what are we supposed to do? Are we supposed to notify members? We're not allowed to reveal the name of the person under privacy laws who may be afflicted, but what is the board to do? What is management to do? Pretty challenging issues. Nick, I know you've had a couple of these too. Might you share a few?
Yeah, I had back-to-back nights of meetings with gated communities, and that's why maybe I spoke a bit about them today's program. But it was about, what steps does an association or what obligations does it have from a gated community for its guards to be enforcing those orders? And there was one side of I can tell you, there was one side of the community through the emails they were getting that was saying, open it up. We have the right to have it open. And we had the other side of the community saying, close it down, lock this down. And, there was reasonable arguments on both sides of hearing the board wrestle with these issues. Of course, as the defense lawyer, I'm saying kind of in line with what Steve's quote was, do more now and it will look better in retrospect. But of course, I don't live there. I guess the moral of it, though, was coming back to what I was saying is ultimately, if there's something done that's consistent with the CCNRs and that debate occurs and it's robust, the importance is make a decision. You're only in real legal trouble, true legal trouble, if you do, one, something contrary to the CCNRs, or two, you don't make a decision at all. And so for me, that's kind of the guiding light that I'm looking at, and trying to make sure that decisions are made, because look, whether you're a board member or a manager or the president or some other governmental official, these are all very difficult decisions to make. The other issue I will say, Steve, is making sure, again, on each one of my calls, those the issues of when you get those emails, people demanding this and demanding that, recognizing, stopping in the moment and saying, oh, I don't just need to have a meeting. I don't need to just get this in front of the board. I might not just need to send this over to legal, but is this an insurance claim? We don't know where it is, and we got to get those out. Again, we don't know where all of these things go, and we want to make sure that we're tendering these things to preserve those insurance policies that are there to protect the boards, the associations, and oftentimes you, the managers. So we want to do that. The last one I've seen also emerge over the last 4 or 5 days. We've seen the unemployment numbers coming out, and a lot of our associations, whether it's condo or plan development, have restrictions on business operations from a unit or from a lot. And we're getting a lot of requests for advice on, can we use rulemaking authority? Well, does a particular business that a member is now operating from their home fall within, oftentimes the professional or administrative carve-out that we see in our CCNRs? And or can we use our rules to try and create some space so that during this very difficult time, people that ordinarily operate their business not from the home can do so to keep their business running? So those are some of the issues I've been seeing, Steve, that I thought were unique.
Thanks, Nick. So like you, we're fielding all kinds of questions. Hope today was helpful. We look forward to working with you, and if we can help you and your clients, please just contact us by phone the way you normally do, or the special helpline email that we have sent up just to deal with virus questions. Thanks very much. Be careful out there.